Hi, everybody. This is Attorney Nathan Doherty at Nathan Doherty Law, PA. Today, we're going to discuss wills, specifically what makes a will valid in Florida. Now, a last will, the whole purpose is it must dispose of all the property. It must say somewhere in there, last will, last will and testament. It has to be in writing that it's a will. It must be signed by the testator. The testator is the person who is making the will. It also must be signed by two witnesses, and everybody must sign in front of each other, knowing they're signing the last will. So everyone has to be in each other's presence, and they all have to sign at the same time. So then what happens? Well, if the will is signed by two witnesses and the testator in everybody's presence, the will is valid. Now, when the testator passes away, both witnesses are needed to prove the will. What's that mean? Well, the will must be submitted to probate court and admitted. Now, a judge needs to know that this is a valid will, and if you have a will signed by the testator and two witnesses, it must be proven. And how we prove that is having an affidavit signed at the courthouse by both witnesses. If it's notarized, then only one witness is needed to prove the will. Now, if the will is signed by the witnesses and the testator, and there's a self-proving affidavit, which is notarized, then the will is considered self-proved and nobody needs to show up to prove that will. Now, self-proving language is different from state to state. Oh, sorry. So self-proving language is different from state to state. We use the self-proving language in Florida. So we have a will, it's signed and witnessed by two people. That makes it valid. However, you need both of those people to show up. And you can see the problems associated with that. Maybe they died, maybe they moved, maybe they scribbled their signature and we don't know who they are or where they are. But it is possible to prove the will if you can find them both. So if you have a will that's signed and witnessed by two people and notarized, then you only need to find one of those people. So that makes it easier. However, self-proved will is the best way to go, where nobody needs to prove that will. It's presumed valid just by having the self-proving affidavit. And then one way to tell if there may or may not be a self-proving affidavit is if everybody signed the will twice. So at the end of the will, the testator signs, the witnesses sign, this is my last will and testament. Yeah, everybody signs. On the next page is the self-proving affidavit, where everybody does the same thing. They all sign it again, and there's self-proving language. And then the notary notarizes the self-proving affidavit. When the testator passes away, you can submit that will to the court, and nobody needs to show up to prove that will in court. That's why I'm a probate lawyer. Basically, I'm a probate lawyer because I'd say half of the wills submitted to court are invalid. Most of them are made on the computer. People make them themselves. They draw up a Word document and say, this is my will, and then they print their name on it. There's a million different reasons why wills are invalid. However, it's done by, if the will is done by an attorney in Florida, 99% chance it's going to be a valid will. So if you're not sure if your will is valid, or if your will was made in another state, other states have different requirements. They may only require one witness. So your will could be valid in Michigan, but not valid in Florida. So if you've recently moved to Florida, please give me a call and consider redoing your estate planning documents. Anyway, that's what I have for wills in Florida. If you like my video, please click like, and feel free to give me a call. Thank you, everybody.